It is 7 o'clock and Tuesday, October the 23rd. Welcome to week number four, already four. I told you the quarter would go very fast. We have 2 more weeks, and then the quarter will be over. And this is actually the second half. And so I am going to spend the next hour or close to it, but no longer than that, giving you information about the assignments and requirements for week 4. So let's go ahead and let me share my screen with you. Here we go. Okay. So you guys are familiar with this page. This is the course home, where you have all kinds of really good information to help you. And I recommend taking advantage of all the resources that I discussed during the open house that are listed here. I'm scrolling slowly now, including tutoring as well, critical thinking, recognizing that the Constitutional Bill of Rights are in here, and we pretty much talked about last week the ones that are the most, the 4th, the 5th, and the 6th Amendment to the Constitution. And then notice that the rubrics are located in each weekly assignment. I go over them, and there are several places you can find the rubric, but the one that I use matches up with your grade book, but it's similar to the one that's in the module. And so you'll see that our lectures will be next week 4 is today. Week 5 will be next week. Now, and so will week 6. Week 5 will take place next week, and then our week 6 lecture will take place on Friday the 2nd. So it will be next week too. So next week, be aware you'll have a lecture on Tuesday and one on Friday. And the reason why is because your quarter ends on that following Tuesday. You'll see what I'm talking about when I look at the calendar. So that's why I said we're moving pretty fast. So let's take a look at the announcement. Court systems and steps in criminal law. And then you should have read chapter 7 and 8 of Criminal Justice, a brief introduction. I provided you also with the PowerPoints to help you study and prepare for that module as well. I'm going to discuss the lecture notes, which includes the court system, the criminal trial process, the participants, and briefly the victim rights. And then I will just show you the practice activity, which I've already encouraged you to make sure that each week that you utilize those practice activities to help you understand the material in that particular module. And then your discussion assignment, your court process, which is a couple of you have did pretty well with that. So your initial postal is not due until tonight, and then your reply post is due Saturday, 11:59 p.m. Central Standard Time. And I've already kind of shown you what I expect by you see your grades from weeks 1 and weeks 2. You just completed week 3 on day before yesterday, so I'll be working on those this week and the early part of next week. But also, I want to remind you to put good content in there. Try to reply to more than one. If you can, that's fine, but make sure that you get your minimum requirements satisfied of your initial post on Tuesday and reply post on Saturday, 11:59 p.m. Central Standard Time. Finally, there's a written assignment, steps in a criminal trial, and a quiz. The quiz I already discussed with you. It is timed. I do recommend that you take that quiz and do it at the end of the week after you've had a chance to go through the materials, listen to the lecture, and things of that nature. And then there's a mid-quarter survey. If you could respond to that, we appreciate that. They're anonymous. I don't know what you say. And then I'll remind you my motto, adversity is the springboard to success, which you know well about what that incurs and why I say that, because of my testimony and story that I gave you during week 1. So let's quickly just kind of gander at the course calendar, which is populating. And there it is. And you can see where we are today. You see this week, your reading assignment. Again, if you click on it, it opens it up and it tells you the same things I just covered. Then your initial post, it tells you the topic, court process, and you know when it is due. And of course, your live lecture here, your reply post on the 27th, your written assignment, and it says written assignment twice because one of them is a quiz and one of them is the actual written assignment, which we will go over in a few minutes. Okay, and then notice when you get to next week, you'll see a live lecture on the 30th, and then you'll see a live lecture on the 7th. This is week 5. This is week 6, because as you can see, your course ends on the 6th. So I don't want to give you a lecture on the last day of class, because you're going to be taking a final exam and all of that. So be aware. Make sure that you attend these lectures and you know what you're supposed to do with the key word that I give you. But you want to make sure that you have paid close attention for this second. That's it. It goes really, really fast on the 6th, and I'll be talking about that more on next week when I get to Friday, not Tuesday. Okay, so let's go right to our module, which is court systems. Again, excuse me, I'm going over the assignments. Notice the requirements. 2 to 3 page paper, not 1 page, not 2, not 1 page and a half, but 2 pages. Does not count your cover sheet and does not count your reference sheet. And you're going to explain the chronological steps of a criminal trial, and then you're going to deal with the day for a jury trial as a final resolution of the case, as you should probably know. And I'll say this in a few minutes, that there are 2 ways that trials are heard. There's option given to every defendant in a criminal trial of a bench trial in which the judge hears and decides the innocence or guilt of a person. And then there is, of course, the jury trial. That is a hallmark. That is a constitutional right that applies in criminal trials. Does not apply in juvenile trials, though, but in adult trials. You're going to identify the participants at each stage and explain their role. Remember, you're going to need to do research. You got this source already that I've been sharing with you. And so APA citations, please, citations in the body of the paper. And the reason for citations, just so you understand, is to provide an ability for us, the reader, or me, the reader, or whoever reads it, to be able to know the sources that you relied on in your statements. I've seen students write great statements, but no citations to support those statements, and I know they got that information from somewhere. You need to give credit to that. You don't have to have citations every other sentence or so, but enough in there to be able to let me know and the reader. And don't just throw one citation for one page, two citations for one page. No, there should be citations throughout the paper. You will lose points if you don't satisfy that requirement. So it is very, very, very important. All right. So write your paper in paragraph form. Don't list the information. Okay. So there's your rubric. You can click on here. But I'm going to show you here where I combine the top score. Same thing, possible 25 points. And again, so let's take a look at what the rubric says. To get 20 points, and then it tells you what you have to do. Okay, which is the same information I just went over. 2 to 3 page requirement. Okay. Very, very, very important. And then your paragraphs, not long paragraphs. Paragraphs should be an average of 5 to 6 sentences. And you should, at this point, be able to write a paragraph, your grammar and your spelling and all of that. And then, of course, your APA sources and citations. And use credible resources. Again, you have a library system that we have embedded in the course to help you to get started. And that will allow you to get 25 points if you get your assignment in on time. Okay, just so you'll know, you can just take a look. If you want to look at this one, you'll see that it's really not much of a difference. You'll just see that I combine the first two sections together. I'm just opening it up just so you can see. And let's make it bigger. There we go. Okay. So here we go. So what I did was I took each of these and made it one. So that's how you get your 20 points. And then you'll see this and this are exactly the same as it is. Okay? So there's no confusion. So you understand. All right. Alrighty, so now let's go back and let's get rid of this one. Let me close this one out so if I stop sharing. Okay, so now we'll go back to sharing. Here we go. Okay, so now we're back where we were. Okay, so now let's go to the next assignment, which you already should be aware of because we've talked about it, and that is your discussion post. By the way, this is the link to the guide to help you with your research, dealing with the weekly assignment, a library tool to help you find resources to help you in your cases or your written assignments. Then your discussion post, and you like I said again, follow the instructions here. And then of course your quiz, time quiz, 16 questions, and then of course your live lecture. Then do your mid-quarter survey, okay? It's a very brief quiz. Not quiz, survey. You're not graded on it, by the way. So now, let's get into the lesson content itself. We already know what we're going to be talking about, the criminal case, the steps, and so forth. I've already given you all of this at the bottom all the way up to here. So we're going to talk about first the court system itself, the process, the participants. So you're going to learn already some of the things that you need to know to help you, and then victims' rights as well. Okay, so let's start out by talking about the court system. As you should know, that our court system is designed to resolve disputes, and there are federal levels, and then there are state levels. The federal laws are created based on most criminal cases. United States Code, USC, if you see that, or USCA, which annotated. It means cases are discussed under the sections. Chapter 18 of the United States Code, USC, is where you find most criminal laws on the federal level. State laws vary and are created by the legislature in each state and will vary. However, though, none of these laws can override the Constitution, and that the courts are the ones who interpret the law. There's an old constitutional case called Marbury versus Madison that said that it is the courts that decide what the statutes mean. In other words, they have the ability to interpret them. And so at your state court level, you have almost the same structure as on the federal. You have a trial court, which some call district circuit court, or and then you have also a court of appeals or appellate court, and then you have a Supreme Court that all states have. Now, if a person is involved in violating a federal issue, such as possibly robbing a bank, there is a probability, a strong probability, that that individual could be prosecuted on the federal level. However, though, sometimes the feds defer to the state in which the crime takes place. So a person, though, is charged with the federal law, such as they mentioned here, tax evasion, will be charged in federal court. Never for tax evasion will be tried in a state court. If a person drives under the influence, they could be charged in state court. And so in every case or trial, there is a formal process where either the grand jury or either a preliminary hearing takes place. And if a person is convicted of a crime, they have a right to appeal. Most jurisdictions give an individual 30 days from the time that they're found guilty in which to appeal. And then it would go to the appellate court, and then if there's issues with the appellate court, then it can go to the Supreme Court in the state. And it could ultimately end up in the U.S. Supreme Court if there's a federal issue that is involved in a civil or criminal case. And so the United States Supreme Court decisions, though, are superior, and they are binding, as it says, on all state and federal courts. Now, we're going to talk about some of the things that take place in the court system. Okay. So let's talk about the criminal process. So when a person is arrested and charged, because the law enforcement agency deals with the arrest, they gather the information, the evidence, the prosecutors look at that evidence and determine if there's sufficient to file criminal charges. Criminal charges are then filed unless the defendant decides to plead guilty to the charges. If the person pleads guilty, we don't have to go through all of that. A defendant could plead guilty and, as I said, have a jury trial or a trial before a judge called a bench trial. Now, I want to say this to you up front. What we're talking about now applies to 10% of cases in criminal court. 90% of cases are dealt with by plea bargaining. I said this before. And I'll just remind you again, when you take Introduction to Criminal Law, you'll already know that. You'll say, oh, yeah, Professor Wright, if you have me anyway, told us of that information. And so in the preparation of trials, with the judge or the jury, it is important that the individual have what we call the right to due process that's guaranteed by the Fifth Amendment, applying to the states through the 14th Amendment. And it is important that trial dates and motions are filed. There's a series of motions that are usually filed early on after an individual is indicted by the grand jury or a true bill is returned by the grand jury. Then there are motions. It could be quite some time from the time a case starts before it actually gets to trial, unless there is a plea. And as a defense attorney, I can tell you that one of the first motions that we file is a motion for discovery. A motion for discovery, or as if you saw the movie My Cousin Vinny, it is called disclosure. And in the process for discovery or disclosure, the prosecution has to share with the defense all of the information that they have in their possession so that the defense can prepare a proper response or a defense, as we say. And so in the process of doing that, there are other motions that could end up taking place, such as if we determine that there was a violation of a constitutional right, such as a Miranda warning, a violation of the Fourth or the Fifth Amendment or the Sixth Amendment, we can file a motion to quash, what we call quash that information, or to have that information excluded from use as evidence in the criminal trial. And the reason is because of the fact that either something happened with the police, law enforcement aspect of the case at the beginning, where they didn't protect the individual's rights by reading them their proper Miranda rights or giving them the proper Miranda rights, or operating with an illegal search in violation of the Fourth Amendment, or questioning the individual after they've said they want an attorney and getting information or statements violation of the Sixth Amendment, the right to have an attorney. So it says here that the pretrial process gives the prosecutor and defense attorney the ability to look at the issues and to file the proper motions. We also file maybe a motion, depending on the circumstances, to have the individual examined by a psychiatrist or to determine their fitness or ability to stand trial, or to determine if there is a possibility of a defense that the individual was not in their right mind when the offense that they're charged with was committed. So anyway, the defendant has many of the rights, and the defendant can waive the right, for example, to motions. They can waive the right to a jury trial, all of those things. Now, generally, it is the attorney who will advise the defendant. In every case that I represented individuals, decided in probably 90% of my cases or more, where they actually were going to trial and no plea was available, to decide to go with a jury trial. And the reason why we often opted for jury trials as defense attorneys is because we feel that individuals who are not lawyers or not, and we try to get people on the jury who could be fair and impartial. We go through a process called voir dire, where we seek to get to the truth, or we seek to have individuals who are jurors who are not biased. We can question them about their position on certain aspects of the trial. And so, uh, in the case of a misdemeanor, you also have a right to a trial. The key is if the person is subjected to going to jail for any amount of time, even if it's one day, they have a right to a jury trial. Okay, and jurors are selected from the database. You have registered voters in some jurisdictions or those with driver's licenses. And there's a random pool that's selected. Probably many of you have received summons to go to jury duty. I've received several summonses to go to jury duty, but I've been able to have to go, but I've always been excused. I'll give you an example of one funny instance that happened. I was a criminal defense lawyer for the most part, and I was in a jury panel, and I was at what we call the Criminal Courts Building in Cook County, or as we call it, 26 in California. Those of you in Illinois and Chicago area will know what I'm talking about. Those of you not, but you have the same thing. So anyway, I was in your jurisdiction. I was in the panel, and I walked into the courtroom with the panel. And the judge looked over, and he saw me, and he says, "Attorney Wright." I said, "Yes, sir." He says, "That's for the jury. You're not supposed to be over there." I held up. I showed him my badge I had on. He said, "Oh, my God." He says, "Could you stand up, please?" He says, "Do we know each other?" I said, "Yes, we do." "Have you tried cases in front of me?" I said, "Yes, I have." "Do you know the prosecutors?" And I say, "Yes." Prosecutors say, "And we know him too." And sometimes even the defense attorneys will. So the judge says, "Okay, you're excused," and let me go, because they didn't want me in there. Because I could get in there, and I could, as a juror, I would probably end up being the foreperson, and they would probably select me to guide and direct them. A little quick example of how juries work. My daughter, I don't know how this happened, my oldest daughter was served with a notice to appear as a juror. And she was selected on the jury, even after the questions. Now, keep in mind, they talked to her about what I've shared with you guys about their grandparents being murdered. They also talked about the fact that she acknowledged that her dad was a criminal defense lawyer, and and that had been a police officer. So they selected her on the jury, and she ended up in the jury. So when the jury heard the trial and it went into deliberation, guess who they selected as the foreperson? Yes, it was my daughter. And I just want to say this to you. With her analytical thoughts of being around me, because she used to go to court with me sometimes and sit at the table and help me take notes and things like that. Well, anyway, what happened is that the jurors, almost all of them, want to find the young man guilty. She refused, and so she hung the jury. So that meant that the prosecution had to retry the case. As a little footnote, they did retry the case, and they found the defendant with a second jury not guilty. So my daughter said, "See, I was right." But anyway, I'm just saying all of that to say that your juries can consist of a mixture of people from various backgrounds. And juries are referred to as petit juries, not the same as the grand jury. The grand jury is a process where for indictment at the beginning of the trial. But when we say juries, we're referring to not grand juries. So don't make a mistake in your writings or your papers and say the defendant can select a grand jury. No, you cannot. The jury, just say jury or petit jury. Be safe and just say jury. So once the jurors, and it tells you here, voir dire, and it explains what voir dire is. If a juror says that they're biased, they can be excused for cause. Also, like I was, because I knew everybody. And the idea is to try to get an impartial juror. It's really hard, particularly in high-profile cases. And then sometimes, as you probably may know, that jurors are locked up or sequestered, as we called it, and kept away from going home, and they can't read newspapers. They can't look at the TV. They can look at the TV, but they can't see news stories or anything like that because they don't want to hear what's going on. They want them to only be exposed to the evidence that comes from the stand in the courtroom. Okay? So the jurors, we have what we call peremptory challenges as lawyers. And that basically means that we can use those and we can say we don't want that person, we excuse this individual, but we don't have to give a reason. Now, once you use them up, then you got to do it for cause. However, there's been constitutional decisions that said peremptory challenges should not be used to discriminate on the basis of race, religion, or national origin, an individual. In other words, you can't use that to stack the jury. You shouldn't be anyway. But it's a very interesting art. Many of us have what we call juror experts, and these are individuals who are psychologists, or that was their area. We paid them, if our defendant can afford it, to help us select a jury. And there's a whole lot to selecting a jury. It's based on body language. It's a very interesting concept. So finally, after jury is selected and the jurors are sworn in, there's usually 2 alternates. And the reason they're alternates in case something happens during the course of the trial, so you still have 12. And so at this point in time, because it is important, jeopardy attaches, which means that you can't start all over again unless there's an error that comes about. And can deal with the Fifth Amendment double jeopardy clause, which we've talked about. So the jury hears the first thing they hear are the opening statements that presented by each attorney. Generally, the prosecutor will present their statement first, and the reason is because the prosecution has the burden of proving beyond a reasonable doubt that the individual is guilty of the offense. And so the statements are given. And now keep in mind this. The opening statements and the closing statements are not considered as evidence, but basically a synopsis. But be aware of the fact that they do play a role in decisions. I can tell you, listening to jurors that we've had a chance to talk to after cases were over, many jurors listened eloquently to what the opening statements were and also the closing arguments or closing statements. Now, in the opening statement, each side presents what their version of what they believe the evidence is going to prove. And so then, after that, then the individuals will then begin their trial. They'll begin the actual testimony. So the prosecution goes first because, again, they have the burden of going forward and determining the innocence or guilt of a person. And so it is very important that the prosecution presents their witnesses. So on what we call direct examination, let's see, I see a comment. Let me go back to that comment. in the chat box because I can't see it. Our clients are denied at the state level. We appeal and request this is the state level. Okay, but this is, I think I saw, you work in Social Security disability law. Yeah, that's civil. That's not criminal. We're not talking about those right now. And once our clients are denied at the state, we appeal and request a hearing. This is a state level hearing. So, no, it's not unusual, but that's civil law you're talking about. That's not criminal. It doesn't apply to what we're talking about today. Because you're not talking about somebody going to jail. You're talking about someone trying to get Social Security disability benefits there. So anyway, the direct examination in which the individuals from the prosecution present their case, and then after each individual, the prosecution then turns it over to the defense, who conduct what we call cross-examination. Now, that's during the prosecutor's case. So, example, the police officer, for example, might testify, whatever. Then the defense attorney will come back and be able to question that individual, and in an attempt to discredit that individual, whatever they testified to, there can be objections. Hearsay evidence is not allowed except under special exceptions. I'm not going to get into the details of that. But anyway, needless to say, there's direct examination and then there's cross-examination. After all of the evidence has been presented by the prosecution, then the prosecution rests. And what that means is that all the evidence that the state has presented. Now, what most of the time many defense attorneys will do, and I've done it before, is request a motion to dismiss, saying that the prosecution who rested failed to provide sufficient evidence for a reasonable jury or for the judge to convict. The judge can then decide whether to dismiss the case and so forth. Let me give you an example on an actual case. This is one that I had. I represented an individual who was charged with, I don't even remember the crime, but I think it was robbery. But anyway, he was one of maybe 5 defendants that were charged. Now, during the time that the prosecution brought forth their evidence, they had witnesses to come in and testify. And during the course of their testimony, they mentioned every defendant except mine. And the prosecution rested after they finished. I held quiet. Matter of fact, I played it smart. Since I didn't hear my client's name on direct examination by the prosecution, I didn't want to cross-examine them, so I left it alone. And the reason why I did that is because of what I'm getting ready to show you now, is that during direct evidence, all the attorneys had questions and so forth. So it came to the end, and the prosecution said they rested, which meant they had concluded presenting their evidence. I stood and said, Your Honor, I'd like to file a request, a motion to dismiss, because during the entire direct examination and cross-examination, my client's name was never mentioned. In fact, Your Honor, my client's name was mentioned at the beginning of the case when the names of the defendants were mentioned, but not one bit of evidence was produced by the prosecution. So the judge says we're going to take lunch and ask the court reporter to go through the transcripts. And the court reporter went through the transcripts, and then we came back from lunch. Then the judge asked me, did I want to persist with my motion? I said, I do, Your Honor. So the prosecution objected and saying, Your Honor, we'd like to move at this time to reopen our case. The judge laughed at them. He says, no, you don't get 2 bites of the apple. You've rested. And now there's a motion before me. So now let's see if counsel's motion will be granted. So the judge turned to the court reporter, and the court reporter said she had gone through and reviewed the entire transcript of proceedings, because this was a 1-day trial. 2 days. And she went through the first day and the second day, and where we were at that time, and said that the young man's name was mentioned 1 time, and it was mentioned at the beginning of the case. Was it mentioned any other time during it? So the judge says, oh, I'm going to grant this motion and dismiss it because you failed to prove your burden, because this young man's name wasn't mentioned. What do you have to say? And then they asked again. The judge stood up on the bench, and he said to them some really derogatory things that I won't go into, but he basically said to them, now you know that that's not going to happen. So anyway, motion granted, and my client and I walked out of the courtroom, and then the case continued. So what I want to do tell you is that most of the time I asked for that motion, as most of us defense attorneys will tell you, we weren't that successful. But it pays to really know your case and pay close attention and be very smart with how you handle it. So anyway, so the trial then continues. Then the defense can put on direct examination evidence, and the same process takes place where the prosecution does the same thing as well. So what happens is that the individual then is heard by the judge or the jury. At the end of the case, then the defense does the same thing, can rest. Now, at that particular point, the prosecution can determine if they want to bring in what we call a rebuttal witness. A rebuttal witness is someone or somebody who comes in to make their case stronger, because maybe during the defense side of the case, they made what the evidence that was presented by the prosecution either null or either weakened it substantially. So then the prosecution has a chance to bring a rebuttal witness to contradict the defense evidence or witness. So so the goal is to erase the doubts that may have been created by defense attorneys' strategies. So now let me explain to you how effective that operates. I had a case that I was representing a young man, and it was a jury trial. And we were doing good. We actually had the case won with our evidence. So I had always advised my clients that when they're in custody not to talk to anyone, especially their cellies, about their case. Well, what happened is that the rebuttal witness that came forth was a guy, and when he came out, my client looked and he said some expletives. I said, Your Honor, may I have a 5-minute recess? So my client explained to me. He said, yeah, I talked to him. He said he was going to help me, and that he knew how to help me because he's been in jail for a while. Well, you know what happened, don't you? He cut a deal, and then he gave evidence to the to the prosecution, and he testified. You know what happened, don't you? My client was convicted because the rebuttal witness's testimony swayed the jury back to the side of the prosecution. So anyway, once the rebuttal is completed, then there are closing arguments, which I talked about early. The prosecution goes first and presents a summary of what they proved from the testimony or the evidence that they presented. Then the defense comes, and then the prosecution gets the last word in it. And once again, people say, well, why does the prosecution get two closing arguments? It's because, once again, the burden is not on the defense, but the burden is on the prosecution to prove beyond a reasonable doubt to the trier of fact that the person is guilty of the crime that they're charged with. Once both sides have presented the evidence, then all the evidence is in, then the judge issues what we call jury instructions that provides the jurors some guidance as to the elements of the offense that they are charged with. And then the jurors are given those instructions. We have in Illinois what we call Illinois pattern instructions that every lawyer in Illinois uses and the judge uses. It's the same every time based upon what the charges are, whether it's murder, robbery, armed robbery, second degree, so forth and so on, aggravated battery. So what happens is that the bailiff then takes the jury in to deliberate. Then the jury can take their time, and once the jury either comes back with a verdict of guilty, then it's read in verdict or not guilty of not guilty, or say they have a verdict, it comes to open court, and the judge then deals with the evidence. And then if the defendant is not guilty, then the defendant is released. If there is a guilty finding, then the judge sets a hearing date for sentencing. Now, sometimes we didn't mention this, but sometimes that individual is out on bail while they're awaiting a trial. But depending on the offense that's involved, the serious offenses, an individual, after being found guilty, is taken into custody, bail is revoked, and the individual is not allowed to go home. Or they will raise the bail. But many times individuals are taken in to custody. And that's how it works. So that's kind of like a summary of what happens. So then after that, I already said this, that the individual has a right to appeal, and after sentencing, then they have a right to appeal their conviction and or sentence. So that individual can only assert what the trial judge did or what happened at trial that were errors. And, for example, if there are things that the defense attorney allows in and does not object timely during the trial, that information is considered as waived and it becomes part of the record, and you can't really use it on appeal. And so then there are transcripts of the proceedings prepared. Counsel is appointed to defend the individual, and then the appeal goes on. In the appeal, there are documents called briefs that are filed, and sometimes that oral arguments take place. Oral argument is not a trial, but what it does, it gives the defense attorney and the prosecution the opportunity to argue the points of law, not the facts. And usually they'll give them a period of time. It says here 20 to 30 minutes to make the arguments. Very brief, very brief. And there is usually a panel of judges. It's not one judge who hears the arguments. It can range from 3 to 9 judges. And then after the arguments, the appellate court takes the case under advisement and reviews, and then issues an opinion explaining their decision. And some go as far as then the state Supreme Court and then U.S. Supreme Court, such as Miranda, Terry versus Ohio. If the appellate court finds no error of law, they will say the trial court was right and the defendant loses the appeal. If the appellate court finds there was a possible legal error, the court reverses the conviction and will remand it. When they say remand, they send it back for the trial court to maybe do something to fix it. Oftentimes, it results in a new trial. But most appellate cases are affirmed on appeal and don't go as far. And that's the process that takes place in criminal court. So now we're going to go through and conclude very briefly that in each of these instances in criminal cases, as I said, the prosecutor determines whether or not or what charges that they're going to try, and the defendant is a person who's charged. The victim is not a party to the case. Listen to me. I'm going to read it to you. Traditionally, victims have not involved in a criminal case other than to provide necessary testimony. In some cases, victims have not been able to participate in plea bargains, which in most cases, or sometimes been aware of the outcome of the case. But a lot of laws have changed. Victim advocates and others have now made it possible for prosecutors to work with victims and keep them advised about what is taking place. And there are various laws in various jurisdictions where the individuals who are victims have a right to know what's going on with the case. And so what the judges allow victims to submit what we call victim impact statements before sentencing an individual. And then this determines how a judge looks at the determination as to what sentence, how it affected the family, such as losing a loved one or something along that nature. And, so victim rights is something that's very, 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 very important. Okay. I do ask you to take time to go through this practice activity and answer these questions. The territory, subject matter, the territory or subject matter, misdemeanor or felony, state or federal, in personam, authority over the person. And you're going to write the answer to that. You will have found that in your reading and or lecture, okay? And so you go through that. But those will help you prepare. Any questions? Any questions? You can type in if there are any. Okay. Well, there being none, it's about 7:53, and I am going to give you the word or words that I'll be looking for, and it's very simple. Criminal trial. Criminal trial. Okay, so I'm going to say good night to you guys, and hope to see you next week. Remember what I said earlier. Next week is week 5. Week 5, we will have a lecture next Tuesday and next Friday. The lecture next Tuesday will be about week 5's assignments, and then the week 6 assignments will be covered that Friday, November 2nd. So, as usual, you know how to reach me if you have any questions. So with that, I'm going to adjourn this session and end this session. Good night.